Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Oh boy, we got a barn burner of one to discuss here today. It's the FTX bankruptcy. I'll have more in just a moment. At the outset, I want to make sure I point that out that everything that is alleged in a bankruptcy is not always proven, that many of the things I'm going to be talking about here are allegations. You should do your own research and come to your own conclusions as to whether somebody did something wrong. The information that I am presenting from here today is available on the Kroll website. That's Kroll, or if you're a ham radio operator, it would be King Romeo Oscar Lima Lima. The Kroll website has the dockets for a lot of the Delaware bankruptcy cases, and it has the one for this case. So, with that out of the way, perhaps you have heard of this company called FTX. It was a cryptocurrency provider. Now, I believe the best way to control my currency is to keep it in my back pocket, in my wallet. As a general rule, I have a very strong distrust of anything new and exciting. And while cryptocurrency is certainly new and exciting, I am absolutely unconvinced that it is safe. In a recent federal bankruptcy case in the Southern District of New York, the judge made a ruling in that case that all of the deposits into this cryptocurrency did not belong to the depositors. It belonged to the cryptocurrency outfit, and that the only thing the deposits created was a debt. And so all of the people who thought they had currency that they owned in this exchange didn't have it. So I'm a little bit of a skeptic when it comes to cryptocurrency, and I think a lot of other people are too. And one of the reasons to be skeptical is the FTX bankruptcy. Now, Mr. Sam Brinkman-Fried has been arrested, and he's been indicted on a number of different offenses. Again, indictments are only allegations. Nothing's been proved at this point. He may wind up beating all of this. But the bottom line is that FTX as an entity went into bankruptcy, and there are some really interesting things about the FTX case that have come to the attention of not just me, but 4 senators in the U.S. Senate who wrote a letter to the bankruptcy judge. Now, at the outset, let me say that it is never a good idea to write to any judge about a case, for one particular reason. The judge can't answer your letter, and 2, the judge can't be swayed by evidence that is presented out of court and unsworn. So when 4 U.S. senators write to this bankruptcy judge and tell him what they think and what they believe, it is effectively an ex parte contact. In other words, it is a contact that the judge simply has to ignore. Now, whether he ignores it is, of course, up to him, but in this particular case, Judge Dorsey has said, I'm not going to be swayed by ex parte contacts. And based on my experience with Judge Dorsey in the Mallinckrodt bankruptcy, I think that's true. I think Judge Dorsey tries to play it right down the middle, by the book. I would also point out that Judge Dorsey is a bankruptcy judge. The reason that's important is because he is not an Article 3 judge. Now, the federal judges in your local federal district courts, they are appointed by the president and confirmed by the Senate. Bankruptcy judges are not. Bankruptcy judges are appointed by the Circuit Court of Appeals in the jurisdiction where they do the appointment, and that appointment is for, I believe, a period of 11 years. The same type of thing, the judges in a district court appoint their magistrates. So it is effectively an extension of the district court in the district where it sits, but the judge is not a district court judge. And while that has some implications for decisions later on down the line, right now it's probably not particularly relevant in this discussion. Judge Dorsey is in charge of this bankruptcy case, and he's going to make decisions in that bankruptcy case, and anybody who doesn't like them has the right to appeal to the district court. So that said, let's talk about a motion that has been made in that case, and let's talk about an objection that's been filed in that case. So we can probably also going to start off talking about the letter from the U.S. Senators. So here is the letter from the United States Senators discussing the FTX bankruptcy case, and here's what they say to Judge Dorsey. We write regarding the investigation surrounding FTX and its case in your court. In recent years, many Americans have followed the explosive growth of the digital asset industry, as well as the recent and highly publicized collapse of its major players. While many factors precipitated these collapses, including poor strategic and business management decisions, as well as, in some cases, outright apparent fraud, these events continually occurred in an environment with weak compliance by the industry and little oversight from agencies that otherwise protect U.S. retail investors. Now, what the senators are saying there is that the SEC and the FDIC, who protect the stock traders on the SEC side and bank depositors on the banking side, they don't get in to protect digital assets. They just don't. And as a result of that, that is a situation where they're essentially unregulated in many respects. They go on to say this: despite glaring and long-standing issues with the management of FTX, Sullivan and Cromwell requests to be approved as the debtor's counsel to this court and admits that it's charged over $8.5 million in legal fees to FTX prior to bankruptcy for advising FTX on a variety of legal matters, including acquisition transitions and specific regulatory inquiries related to certain U.S. business lines. The very issues that may be considered by this court and certainly will be considered in related civil and criminal matters. Additionally, somewhat shockingly, Sullivan and Cromwell claims it is disinterested within the meaning of the U.S. Bankruptcy Code. And we will get to that here in just a minute. It go on and they say, yet significant questions about the firm's involvement in the operations of FTX remain unanswered, including the extent to which Sullivan and Cromwell attorneys had questions or suspected fraud, or the absence of appropriate legal controls, the actual scope of Sullivan and Cromwell's representation of FTX, and if not Sullivan and Cromwell, which law firm actually served as the primary external counsel to the debtors. So basically what the senators are saying here is that it appears to them that Sullivan and Cromwell is not truly a disinterested bankruptcy counsel. Now, there are two kinds of lawyers whose appointments are accepted in bankruptcy. One of them is the primary bankruptcy counsel, the counsel that will oversee and provide legal support for the bankruptcy. As I have mentioned before, this is a Chapter 11 bankruptcy, a reorganization. And so because it is a reorganization, management from the corporation remains to run the business. So Sullivan and Cromwell will have to advise that management, assuming that that's the way this actually shakes out. But that's not necessarily the way that it would always work out. Another type of attorney that is appointed is, of course, attorneys who provide services in the regular course of business. So, for example, where FTX might be sued by an investor, well, that would be basically a defense firm, and if there is a defense firm that is retained prior to bankruptcy, usually that retention will continue in bankruptcy, assuming there are no overt and actual conflicts of interest. So one of the things the U.S. attorney, the U.S. trustee, who is a division of the U.S. attorney, has done in this case is they have moved for an appointment of an examiner. In fact, they filed a motion to that effect in the bankruptcy court, as you can see here. Now, what that means is they are asking the court to appoint an independent person to look into the allegations regarding how the collapse occurred. And here's what they say. Here's what the trustee says. An appointment of an independent examiner would be in the interest of the debtors, creditors, and other parties in interest in the debtor's estates consistent with Code Section 1104C1. An examiner could and should investigate the substantial and serious allegations of fraud, dishonesty, incompetence, misconduct, and mismanagement by the debtors, the circumstances surrounding the debtor's collapse, the apparent conversion of exchange customers' property. Now, conversion there doesn't mean changing from one form to another. It means essentially stealing or misappropriating those assets. And whether colorable claims and causes of action exist to remedy losses. The appointment of an examiner is mandatory on under 11 U.S.C. 1104 because the debtor's fixed, unliquidated, unsecured debts to its customers alone far exceed the $5 million threshold. So, the U.S. Attorney is saying, hey, absolutely an examiner is required here. Now, I have not seen where the debtor has come back and said, no, we're all okay. But let me just put it to you this way in a hypothetical. What do you suppose would happen if I walked in to the FBI and I told the FBI, look, I know the Third National Bank down here on 5th Street was recently robbed. I have investigated myself, and I have determined that I did not rob the bank. I would be in a cell so quickly, your head would spin. But fortunately, I'm not stupid enough to either A, rob banks, or B, go talk to the FBI if I had. But the bottom line is still the same. It is never appropriate for somebody who may be involved in misconduct to investigate its own misconduct, because inevitably what happens is they come back and say, hey, we investigated ourselves and we didn't do anything wrong. Trust us. Really? We can be trusted. Really? That's how they do this, right? But that's not going to work in this particular instance, I don't think, because an examiner is an independent body. He gets paid by the bankruptcy estate, and he is empowered to look into all of this. He has subpoena power. He can depose individuals and all of that. Now, I feel bad for the examiner if one gets appointed here, because he's going to run into all kinds of problems with the Fifth Amendment. When he goes to depose these different officers and directors of the corporation, they are all going to lawyer up, and they are suddenly going to have forgotten everything they ever knew. And if they haven't forgotten it, they will simply assert the Fifth Amendment. So it's going to be a document-intensive look at the corporation. It'll be interesting to see what happens. But here's the other interesting thing. This is the objection that was filed in the case, and it relates specifically to the retention of the law firm Sullivan and Cromwell. Now, Sullivan and Cromwell is what we plaintiffs lawyers like to refer to as a white shoe firm, meaning that the people there do a lot of corporate work. They don't do a lot of nitty-gritty work. They don't go try accident cases. Basically, they represent corporations, and that's all they do. But here we have an amended objection to the application for an order authorizing the retention and employment of Sullivan and Cromwell. And here are some of the things that that objection says. Sullivan and Cromwell was one of FTX Group's primary external law firms before the group collapsed. To date, FTX Group has paid the firm more than $20.5 million in fees and retainers. Now, in the most flagrant attempt by the Fox to guard a henhouse in recent memory, Sullivan and Cromwell has applied to be appointed the FTX Group's Bankruptcy Counsel with duties that would include investigating all potential estate causes of action. But it has revealed almost nothing about its pre-petition work for Sam Bankman-Fried's fraudulent enterprise and failed to disclose or elided glaring conflicts of interest. Sullivan and Cromwell is not only an inappropriate candidate for appointment as FTX Group's bankruptcy counsel, it is a target for investigation with its own potential liability. Its appointment as counsel would endanger the estate and create a rigged game, undermining creditors and the public's faith in the bankruptcy process. The court should therefore reject Sullivan and Cromwell's application and disqualify it from appointment as debtor's counsel. So, essentially they are saying Sullivan and Cromwell is not an answer to the problem. Sullivan and Cromwell is part of the problem to begin with. Again, those are allegations. They're made by an independent debtor in this case, or I should say independent creditor in this case, and we will see what happens with those allegations. But some of the allegations they make are pretty interesting. One of them is, contrary to the impression it now seeks to create, Sullivan and Cromwell's pre-petition connections to the FTX group are legion. Sam Bankman-Fried himself revealed that Sullivan and Cromwell was one of the primary external law firms that represented FTX US as well as FTX International before the group's collapse. In addition, 2 former Sullivan and Cromwell lawyers sat at the top of FTX Group's internal legal structure. FTX's U.S. General Counsel, Mr. Ryan Miller, is a former Sullivan and Cromwell partner, and FTX Ventures General Counsel, Mr. Tim Wilson, is a former Sullivan and Cromwell associate. Now, here are the other interesting things they say. They say Sullivan and Cromwell's application did not disclose the firm's connection to FTX U.S. General Counsel Ryan Miller or FTX Ventures General Counsel Tim Wilson, nor did Sullivan and Cromwell's application describe the work it did for Alameda silo entities, which were pre-petition Sullivan and Cromwell clients and are known to have been at the heart of the FTX group fraud. Next, Bankman-Fried wrote, Sullivan and Cromwell chose John Ray to run the Chapter 11 team, while at the same time informing him that, or assuring him that he would get to choose the board chair. Bankman-Fried finally relented on November 10th, signing documents nominating Ray as the CEO. Almost immediately, he claims he expressed a desire to rescind the document and was told it was too late. Well, who told him that? I'll tell you who told him that. It was FTX as General Counsel Sullivan and Cromwell. Or I should say the FTX General Counsel and Sullivan and Cromwell. Bankman-Fried closed his description of Sullivan and Cromwell's role with a screenshot of a message by Ryan Miller purportedly sent to much of FTX's leadership on November 8th, 2 days before Ray was nominated as replacement CEO, and the alleged screenshot is reproduced here. It says, I need to wire Sulcrom, that's Sullivan and Cromwell, $4 billion to make sure we are all represented through this and we preserve any value that is left. Tomorrow from FTX Cash. Who can do it? I'm in charge now. So it would seem, at least from the plain text of that message, that the Sullivan and Cromwell former partner and U.S. General Counsel decided that there was only one place to go for legal help. That was Sullivan and Cromwell, because they were the primary pre-petition legal counsel, and that's who he chose. In other words, he didn't evaluate other, perhaps unconflicted counsel. Now let's look at what the Third Circuit, which is where this bankruptcy court sits, says about this particular thing. Here is what the Third Circuit has said about some of these disclosure requirements that both the U.S. attorney, or I'm sorry, the U.S. trustee, as well as the objector here have made reference to. Also, the senators have made reference to it. Here's what they say. Furthermore, simultaneous representation of a debtor corporation and the controlling shareholders, although not a disqualifying conflict per se, becomes a basis to disqualify counsel where adverse interests either exist or are likely to develop. Now, in this situation, you have to question whether or not those are likely to develop here, given the fact that Mr. Bankman-Fried has been indicted. Here's what they say. With regard to preferential transfers, courts also have held that such transfers to a professional constitute an actual conflict of interest between counsel and the debtor and would require the firm's disqualification. If a professional is determined to have received a preference, its resulting claim for fees would transform it into a pre-petition creditor which would pose a disqualifying conflict. Rule 2014a, it effectuates 327's disinterested requirement and mandates that a debtor's application to employ the professional be accompanied by a verified statement of a person to be employed, setting forth the person's connections with the debtor, creditors, and any other party in interest, their respective attorneys and accountants, the U.S. trustee, any person employed in the office of the U.S. trustee. That's quoting Rule 2014. The professional seeking to be retained must make full, complete, and timely disclosure of all the professional's connections to the debtor, creditors, and other party in interest. So when they talk about the connection, that is not, in other words, you don't have to disclose just what you know to be a conflict. You have to disclose relationships that exist between these differing parties. The Third Circuit has stated that under the rule, all facts that may be pertinent to a court's determination of whether an attorney is disinterested or holds an adverse interest to the estate must be disclosed. These disclosures are not discretionary, and lawyers cannot pick and choose which connections are irrelevant or trivial. Furthermore, it is not the obligation of the bankruptcy court to search the record for possible conflicts of interest. Instead, that obligation belongs to the party who seeks employment by the estate. Courts have held that professionals who do not proceed carefully under the rule do so at their own risk and can lose their remuneration under the rule. So this is what the Third Circuit says about disclosures by bankruptcy attorneys trying to get retained as counsel for bankrupts. It says the professional seeking to be retained under Section 327A bears the burden of establishing that it is both disinterested and does not represent an interest adverse to the estate. In determining whether an attorney holds or represents an interest adverse to the estate, the Third Circuit has held that Section 327A mandates disqualification when there is an actual conflict of interest, allows for it when there is a potential conflict, and precludes it based solely on the appearance of a conflict. So that's where the conflict is, that's where the objection is based on. The Third Circuit has also held that a conflict is actual and hence per se disqualifying if it is likely that a professional will be placed in a position permitting him or her to favor one interest over an impermissibly conflicting interest. The Third Circuit eschews bright-line rules in determining whether or not the given arrangement constitutes an actual or potential conflict of interest. Accordingly, denomination of a conflict as potential or actual and the decision concerning whether to disqualify a professional based upon that determination in situations not yet rising to the level of an actual conflict are matters committed to the bankruptcy court's sound exercise of discretion. Well, as I indicated, Judge Dorsey tends to play things right down the middle, and he will apply the bankruptcy code rigorously in this case. Does that mean he'll appoint an examiner? I don't know. It's going to depend on the evidence that gets presented. Does it mean that he will grant the objection of the objector to the retention of Sullivan and Cromwell? Again, I don't know. It depends on how the evidence comes in, what evidence is presented, and what discovery is permitted before that hearing gets held. My guess is that there will be a deposition of people that occurs before there is ever a hearing on this, particularly the general counsel, the associate general counsel. There will be a number of depositions, and there'll be a lot of document production that happens prior to a hearing on whether or not Sullivan and Cromwell should be retained. And if the court concludes that they are indeed conflicted in this case, because certainly in this case they have failed or refused to provide information on all of the connections in this case, because clearly FTX and their general counsel had a connection with Sullivan and Cromwell because that's where they came from. And the fact of that connection is pretty clear when the only decision that gets made is to hire Sullivan and Cromwell to represent them. Again, what Judge Dorsey will do with those facts is his discretionary ruling. He will have to make a decision based on the facts that come in. And then, like I said, if somebody objects to that, they can not only file an appeal, but in some cases, they can take a writ of mandamus to a higher court and get some relief in that manner. This is going to be a very interesting bankruptcy case to watch. Kroll has a service where they can, I believe, send you recent filings that come in on a case if you sign up for them. Sometimes I think that's an interesting idea if you're interested in this area of the law. And if you're a crypto victim of Sam Bankman-Fried or FTX, then it's probably worth your time to do that. And by the way, if you haven't hired counsel to file a claim for you in bankruptcy, you need to do that. Very shortly, there will be a cutoff date for claims to be filed, and if you do not get your claim filed within that period of time, it will be forever barred. You will never be able to get it from anyone associated with this bankruptcy. So that's what I have for you today. I hope you found this interesting, educational, fun. It'll be interesting to see what happens if indeed there are conflicts of interest disclosed. There may actually be a referral to the disciplinary boards of the attorneys involved. But again, that is something that has to happen further down the road. Thank you so much for watching. If you would, like, share, subscribe, pass this on to your friends. If you know somebody who has an FTX case, there are some really good bankruptcy lawyers in Delaware that I'm aware of. I'd be happy to give you their name. Because we've used them previously in other cases. Thank you again for watching. Have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.